Jury Series Part 2. David Lammy's proposal. Reducing the role of juries. Justice Secretary and Deputy Prime Minister David Lammy has unveiled far-reaching plans to reduce the use of jury trials in England and Wales, framing them as necessary responses to deep-seated problems in the criminal justice system. The government points to a massive backlog of unresolved cases, with tens of thousands of criminal trials waiting to be heard in Crown courts. Some trials are currently being scheduled years in advance, and he points to pressure on courts, prosecutors and defence lawyers, saying they are intense. Lammy and his allies describe the situation as a court's emergency that demands bold action to prevent further delays to justice for victims, witnesses and defendants. Part of the justification for limiting jury trials is that non-jury, judge-only trials are faster. Government figures suggest that judge-led trials in new swift courts could take around 20% less time than jury trials, potentially freeing up capacity and reducing waiting times. Lammy has also argued that allowing magistrates increased powers and reducing the number of cases going to Crown courts will ease the burden on the system. The government has tied these changes to wider reforms recommended by former Judge Sir Brian Leveson, who reviewed the criminal courts earlier in 2025 and suggested some contexts where jury participation might be limited. Leveson's review was commissioned because of the persistent backlogs that have grown since the pandemic and due to long-term issues facing court infrastructure and staffing. Below is a clear bullet point summary of the proposals. The third article will challenge and scrutinise each of them. Stated reasons for the proposals. The Crown Court backlog has grown to tens of thousands of cases, with long delays before trials are heard. Victims, witnesses and defendants are waiting years for cases to conclude. Jury trials are said to be time-consuming, expensive and logistically complex. The government argues that faster trials will restore confidence in the justice system. Pressure on prisons and probation services is cited as part of a wider system under strain. The proposals are presented as emergency measures rather than permanent ideological reform. Removal of jury trials for lower-level offences. Defendants facing potential sentences of up to 3 years would no longer automatically qualify for jury trial. These cases would be heard in new judge-only swift courts. The stated aim is to reduce trial length and free up Crown Court capacity. Expansion of magistrates' court powers. Magistrates would gain increased sentencing powers, potentially up to 18 months imprisonment. More cases would be diverted away from the Crown Court system. This is intended to reduce pressure on higher courts and speed up case throughput. Reduction of defendant choice. For either way offences, defendants may lose the right to elect trial by jury. Courts would decide whether a case proceeds in Magistrates' Court or Crown Court. The government argues this prevents unnecessary escalation of cases. Judge-only trials for certain complex cases. Some complex fraud and financial crime cases could be tried without juries. Judges would determine guilt alone, based on written and oral evidence. The justification is that juries struggle with highly technical material. Changes to jury composition and process. Proposals include exploring smaller juries or streamlined jury procedures. Judges may gain greater discretion over juror selection and suitability. These changes are framed as efficiency and fairness measures. Safeguards claimed by the government. Serious offences such as murder, rape and violent crime would retain jury trials. The government states that judicial independence and fairness will be preserved. Reforms are described as targeted and proportionate, not an abolition of juries. The WEU has simply just set out the government's proposals in this second article, so members are fully informed ahead of our detailed critique in the next piece. The first article examined why trial by jury became a cornerstone of justice in England. This article explains the proposed changes, and the third will set out why the Workers in England Union oppose Lammy's proposal.